quite a lot.
All right, in the interest of keeping things moving and trying to bring this to a logical close, I don't know why I'm the moderator for the close, but I guess maybe I volunteered. But, you know, we had a serious set of discussion topics planned, some of which have already been covered. So we're going to try and pivot a little. Tim Syrett is on the screen here, one of our important panelists. And Tim, as many of you may know, he's a partner at WilmerHale and is, I would say, that of course, you know, WilmerHale represents Apple and many people on the Apple side of the equation, although Apple's on both sides of the equation. And oddly, on the left, we have the patent holders, Fabian, who everybody knows, and John Kolakowski. And on my right, we have an attorney, Dave Djavaherian, you probably know, and they're going to introduce themselves some more, but obviously they're very steeped in international patent, litigation, licensing, transactions, regulatory issues, and so forth. So our topic is governance, and we had a little difficulty trying to figure out what we were supposed to talk about. And then just thinking about what's gone on today, I thought it does jive with our prep that we're going to look at the four big jurisdictions, the courts that seem to be driving governance. We're going to talk about the standard setting organizations that drive governance, and then just try and unpack some of the big decisions that are driving behavior. So maybe that's a good way to say it. And we're going to start with each of the panelists highlighting some of their experience, but then focusing on a jurisdiction. So I have assigned each of the four panelists a jurisdiction. So we'll kind of see what they have to say about that jurisdiction in terms of some of the current challenges, and then we'll kind of take it from there. So I think we're going to start with Germany and David.
Okay. Well, hi, everyone. Before I start, let me thank again Tim, thank Justice Barron, and thank Qualcomm for setting this up. I think it's been a great conference, a great day, and a great collection of folks. So thank you all. You asked me to talk about Germany and about some of the issues that have been going on in German litigation. Obviously, I'm not a German lawyer, but I have some clients that have dealt with the German legal process. And I'm going to come at it from the direction of what I'll call extraterritoriality. And the concern that I have with the way that the German legal process is currently functioning, and it's similar to what's happening in the UK, is that injunctions are being used in Germany to require licensing of and set rates for US patents, as well as other international jurisdictions. We have national patent laws. That is a fact. The right to charge for a patent comes from the rights granted under US statute, under national patent law. If I were a US court or a US policymaker, it would give me great distress to know that a judge in Germany is deciding how much a US company should pay for a sale of a product in the United States based on alleged rights under a US patent. The German legal system is doing this by virtue of what I view as a bit of a odd argument. The argument is that the German legal system has the right to grant an injunction if there's infringement of a German patent, which of course is true. The German legal system also has the right to set rates for German patents. But where there's a oddness and an expansion to the logic is this notion that FRAND is necessarily international. And so the rights under one German patent and the ability to issue an injunction for that one patent are being used to say, well, if you don't accept a FRAND license on a worldwide basis and pay for every sale you make in China, every sale you make in the United States, every sale you make in any other jurisdiction, then based on one German patent, we're going to enjoin you and cause you to pay, or cause you to pay for tens or 50 or 100,000 foreign patents that aren't at issue in this litigation. And I think that is encroachment upon the US courts, encroachment upon the US legal system, and it's something that from a trade perspective, the US government administration should be very worried about. And from a judicial perspective, we should be talking more about. It's not hypothetical. We're seeing American companies take licenses for American sales because they can't afford to be shut out of the German market. And I think that is an issue that we're going to see play itself out quite a bit more as the law develops in Germany, as the law develops under the UPC, the Unified Courts Act, and it may even make its way to the ECJ or to some of the competition agencies. But I think there's some issues there that we've got to recognize as U.S. lawyers. Could cause some heartburn among folks thinking that the right place to adjudicate rights under U.S. law is in the U.S. courts.
Great. And I know Fabian has something to say about this, but why don't we go through?
When has that ever not been?
But I think we'll go through, each person will have something to say about each jurisdiction.
If Fabian doesn't speak next, I'm just going to assume he agrees.
But so we'll each go once, and then we'll have counterpoint. So Tim, hey Tim, can you hear us?
I can, yeah.
Tim's going to talk about U.S. Thanks, Tim.
Yeah, thanks. I'm sorry I can't be there in person today, but I appreciate the opportunity to participate remotely. So in the U.S., I think the courts, in opposition to what Dave was saying, I think the courts have recognized the limits of their jurisdiction. They have realized that just because parties have made FRAND commitments, it doesn't give a court the right to impose on a licensee a global license. And we haven't seen U.S. courts try to do that. The circumstances where U.S. courts have engaged in portfolio-wide adjudication, including of foreign patents, are in situations where the licensee has generally requested it, such as Microsoft, Motorola, and where both parties have agreed to it, have seen it as an expedient route, as opposed to jurisdiction by jurisdiction litigation, to have a U.S. court set a rate. And I think in doing that, U.S. courts can serve an important function. I'm sure we'll get more into different variations across jurisdictions, but I'm sure there are many reasons that a licensor or a licensee might want to have a U.S. court involved. But I think U.S. courts have recognized that it's got to be in the right circumstances. They can't take a portfolio and make a company take a license to it because, as Dave was saying, they don't have jurisdiction over Chinese patents or German patents. And so there's no legal obligation on the part of a licensee to show up in U.S. court and have a rate imposed on them on a global basis.
Thanks, Tim. I think, John, you're next with the UK.
Sure. Hi, everyone. And sorry, it's a little bit of an odd seat. Apologies to the people over there whom I can't really see. So the UK, the state there is, I would say, similar to the description that Dave gave of Germany, in the sense that we have this important Unwired Planet v. Huawei decision that confirmed first that there was no freestanding FRAND claim that could be brought in English court. You had to tie it to the existence or non-existence of a legal right, like a patent infringement claim. But in that decision, then the court held that even without the consent of the parties, the English High Court determined that it has the power to determine the FRAND offer to be made to the defendant in the case of an infringement. The defendant could then choose to accept it or be excluded from the UK market. And the UK Supreme Court then later affirmed the notion that the rate can be a global portfolio rate if the party's evidence suggested that that would be customary in the industry, if it was what the reasonable parties would have agreed to under the circumstances, and if it's within the bounds of the relevant SSO commitment that would be applicable to the dispute. That decision also established under UK law that FRAND is not hard-edged, meaning that different rates could be offered to different licensees consistent with the non-discrimination requirement as long as there was no distortion of competition. Then more recently, this past October, we had another important decision, which is the Optus v. Apple case. There we had Justice Mead concluding that Apple had infringed a valid Optus patent and would be enjoined from selling in the UK unless Apple would unconditionally commit to licensing on whatever terms the court was going to later conclude were FRAND at a later trial. Apple initially made some noise about potentially leaving the market and balking at that restriction, but eventually capitulated, and there's actually, as we speak, the ongoing FRAND trial occurring in the UK to determine that rate. And that's where we are in the UK.
Thanks, John. And Fabian, thanks for volunteering to talk about China. I know you're not a Chinese law expert per se, but you certainly understand it.
Well, I am certainly not a Chinese law expert, and I'll give the disclaimer I always give at these things now, which is my views are mine. I don't want to attribute them to my company or my colleagues, basically because I want to speak my mind and not feel constrained. With respect to China, the big concern is, well, what are they doing with standalone FRAND determinations? Because it seems they are entertaining them. They are taking jurisdiction of them. They're issuing anti-suit injunctions. They did in Samsung versus Ericsson, for example. There are other cases that are ongoing. And there's even been some filed on the plaintiff side, right, or on the patent holder side, where ZTE has filed a FRAND determination case for a determination of a rate on its portfolio, and all of that seems odd and non-standard to those of us used to litigating in other jurisdictions where it has to be tethered to some claim or there has to be some contractual issue before that kind of factual determination is made. And so there's a lot of concern and sturm and drang about what is going on. What are Chinese courts doing? Is this a China industrial policy that they're going to try to take control of all of FRAND and all of that? And I don't know the answer to those questions, but I will give you my take. I think this started after the UK decision that John just talked about after Unwired Planet. There was a feeling that, and a lot of the rhetoric, Dave started, courts are setting worldwide jurisdiction, they're interfering with the jurisdiction of other countries, et cetera, et cetera, et cetera. There's all of that. And in particular, China's jurisdiction was offended because it was Unwired Planet versus Huawei. And Huawei had argued for it being decided in China, and the UK court had said, no, we're here and we're going to do it. And so after that, Chinese courts started doing it. Subsequently, the UK courts made clear what John said, which is that it has to be tethered to a real claim. It has to be tethered to something, some other existing legal right before courts will do FRAND determination. Basically, what the UK courts have done is, set FRAND rates or determine what a FRAND license looks like as part of determining whether an injunction should issue or not. Now we could talk about whether they're doing it the right way or all of that, but that's what they're doing. And that's not what was happening in China. China was just doing standalone FRAND determinations, or at least that's what they seem to be suggesting they were going to do. And my view is that now that the UK courts have made that clear, I am very interested to see how this develops in China. Because my experience in dealing with China and the Chinese legal system is not quite the same as my friend Eva's. I wouldn't say there's no rule of law. It's just that the legal system is different. The judicial professionals, the judges, are legal professionals. They care about getting things right and resolving disputes. Now, the judiciary isn't independent, and 100% there are other considerations that come into US courts, come into Chinese courts that are odd from a U.S. point of view. But by and large, the Chinese courts function as other courts do when not adjudicating politically charged disputes. And so when you have a lot of these disputes aren't politically charged. If you have ZTE suing another Chinese company, it's not clear to me that that's going to be a politically charged dispute in China. If you have Samsung suing Ericsson in China, I'm not so sure that that's a politically charged dispute, and I'm not surprised that that ended up going pretty much nowhere. So I think that my expectation or my hope is that China will end up in a rational place, and the law will develop there much as it's developed in other places. And hopefully we'll talk more about how the law is developing.
Thanks, Fabian. So maybe we go back to Germany for a minute and have some more views on, are the German courts really forcing companies to take global licenses, unfairly, so to speak, because of the injunctive threat?
I mean, I don't know. So a rose by another name is still a rose, right? And I understand what Fabian's saying, that, well, you got this contract right, and this and that. The defendant didn't sign a contract, first of all, but even if it did, that's not what's happening. What's happening is a judge in a foreign jurisdiction, whether it's the UK or whether it's Germany, is telling a defendant how much they should pay for the right to use a US patent. That is an adjudication of US law. And you can wrap it in all sorts of theories and explanations, but that's what's happening. My question, going to Fabian's comments about China and the grief that has befallen those who have used anti-suit injunctions. Remember, anti-suit injunctions are a US invention as a protection against the use of foreign injunctions to set rates. The US courts created that. The Chinese courts have borrowed it. To use another metaphor, is what's good for the goose good for the gander? How can it be the case that a plaintiff can go to a foreign court and seek properly a rate setting for its entire worldwide portfolio on a global basis, including US patents, while a defendant cannot go to a US or any other foreign court and seek a rate setting for the same portfolio? The plaintiff can do it, but when the defendant tries to do it, it's a bad thing. That can't be the right result. Either nobody should do it or everybody should do it. Maybe the best thing to do is, if we agree that foreign injunctions won't be used to set rates for US patents, then we won't issue US ASIs to prevent the foreign injunctions. But you can't have rules where foreign courts are setting rates on a worldwide basis while sanctioning parties that seek rates in foreign jurisdictions for the same exact portfolio. You can't prioritize your own court by using injunctions to do so.
But courts aren't the ones that are telling the parties what they have to spend for US patents. They're saying, was the offer frank? So it's a patent holder that's saying, you should pay me X for this portfolio of patents, which includes US patents. And then the court has to evaluate, the court is evaluating, did the patent holder comply with its frank commitment in giving that offer?
So the court's just kicking you out of the country, but they're not actually telling you what to spend. They're just saying the court
is kicking you out of the country because you're an infringer, right? That's the ultimate. That
seems like sophistry.
But it's not like sophistry, because at the end of the day, courts have to figure out what remedies to impose for infringement. Yes. All infringers would like there to be no remedy. 100%.
A rose by any other name is still a rose. If you're setting rates,
it's a rose that by any other name is still a sweet. But a rose that's a tulip is
one thing. I'll just break it up here for a minute. I've now been assisting definitely implementers in UK and German litigation over What's Fran. And one of the things that really troubled me was that, a couple of years ago, the judges weren't really getting into the numbers, and that was just very frustrating to me. But now it seems like the judges are actually going to take some evidence, albeit through the attorneys, not actually through the experts. Maybe that'll come, where they have to kind of understand each side's position on the number. Is it really FRAND?
Is it really FRAND? Yeah. Look, is worldwide even FRAND? It might not be in all cases, 100%. The UK, the Unwired Planet didn't decide for all time that a FRAND license is worldwide. It said in the circumstances of that case, a FRAND license would be worldwide. There are certainly situations that you can imagine that wouldn't be the case. But the question is, did the patent holder comply with its FRAND commitment?
Yeah, but anyway, Tim, I want to bring you into this a little. What's the remedy for a company, a U.S. company that's got this injunction? Do they have any remedy in the U.S. to, block the global license somehow? What's their course of action?
If a U.S. company is enjoined in Germany, what do they do?
Yes, sorry, that's off the script.
Yeah, no problem. I mean, I don't think there's necessarily a great remedy. I mean, I think that's the effectiveness of the German system for the patent holders, is that they apply these standards that, as you alluded to, sometimes they're not even looking at the offers. They're just kind of, it seems almost like mind reading about your degree of willingness. And if they find you not willing, which seems to happen more often than not, then you suffer the injunction. And I don't think there's much you can do at that point. I mean, a U.S. court is not going to overturn the findings of a German court about infringement of a German patent. But as Dave says, it is going to have the effect that you're out of the country unless you agree to the global rate. So I do think that system, the German system, the UK system, it really does give a lot of leverage, holdout power to patent holders to impose terms globally on licensees. And I mean, the thing that's always stuck out to me about the UK decisions is they talk about, well, the licensee can go around the world and invalidate the patents and decrease the royalties. Well, if the patent holder can't even be expected to go enforce its patents, how can it be that it's the licensee that they should then take on that burden to decrease the royalties after it's been subject to a global license? So I'm not sure. I don't think there's a great answer. And I think that's why you see patent holders flocking to Germany and other courts in jurisdictions that will similarly impose injunctions in major markets, because it really does give you just a ton of leverage.
Thanks, Tim. On the UK front, the Unwired Planet decision was, 4 or 5 years ago? It's been quite a while. There's been a series of cases filed since then, two of which I actually put evidence in. So it's been a while since a case actually went to decision. We don't have a second Unwired Planet decision. I have some theories about why, but John, do you have any theories about why these cases they've been settling? The cases have been settling. Now we have Lenovo, InterDigital Lenovo it's waiting for a decision. So will it settle before the decision? I don't know. And by the way, all the testimony of the experts is transparent. Well, somewhat transparent. It's a lot of redactions, but you can actually, kind of get a feel for the two sides. But I'm just wondering if there's any thought on why cases have been being settled.
Well, I think I would say it's the threat of the injunction. The more realistic threat of the injunction there in the UK puts a greater level of risk on the implementer that perhaps wasn't there before, or was only a theoretical risk, whereas now it's become more of an actual and more likely risk that they will have to incur. And I think that tends to balance out the incentives for both sides to come to a negotiated agreement rather than having to wait and have that problem resolved by the courts.
Any other thoughts on that?
Certainly being shut down will give you a strong incentive to settle a case. That does not mean that the settlement amount is FRAND. One of the biggest concerns that I have about licensing practice today is that rates are being set not based on the value of the technical contributions that are patented in the SEPs, but based on the possibility, the likelihood, the actuality of being kicked out of business and enjoined in a particular jurisdiction, particularly in Germany, in some cases in the UK. And so I do think it's a powerful incentive. I just think it's the wrong incentive that gets us to the wrong solution. You can't have patent holders, on the one hand, refusing to agree to a neutral rate adjudication, right? Because they're afraid of what rate might come in, while at the same time going to foreign jurisdictions and seeking injunctions to force the rate that they prefer. That demonstrates that they're afraid to know what a US court applying US apportionment rules would find their proper FRAND rate to be, and instead want to use the power of the injunction and the threat of the injunction to force the rate that they believe is appropriate, regardless of whether it's appropriate under applicable law.
But in all those instances, Dave, the injunction is only obtained after a determination by the court that the rate offered has been FRAND.
Well, a rate offered in Germany for German patents is the province of the German courts. A rate offered in Germany for US patents is the province of the US courts. Whether a US court would find a particular rate to be FRAND for US patents is not really the province of the German court. And while the German court may say, I've looked at 5 comparable licenses, and in the German legal system, we look at comparable licenses, and that's our basis for determining FRAND rates. And therefore it looked comparable, so we're gonna find it FRAND. That is not the same as a US court saying these are US patents. We look at parallel licenses, but we also look at apportionment, and we assess rates based on that legal basis. And using that legal basis, I find the rate to not be FRAND. I heard earlier the suggestion that if a party doesn't agree to a rate that's later found to be FRAND, they shouldn't have the option as a defendant to take the rate license anyway. They should just be enjoined. Now, what's the equal and opposite of that? Well, if the patent holder offers a rate that isn't found to be FRAND, what should the penalty against them be? How do you?
They don't get an injunction, and there's no enforcement. They don't get no compensation. Is the penalty?
So they get $3 instead of $5. That's their penalty. Whereas the defendant gets kicked out of the country. That's not a penalty. That's a FRAND rate. What I was told earlier was that to encourage negotiation, you have to penalize a defendant who doesn't accept a rate that's later found to be FRAND. But I see nobody advocating for a penalty against a patent holder who seeks a rate that's later found not to be FRAND.
Well, hold on a second. First of all, if a rate is found to be FRAND in the UK, right? The UK sets the rate. It's found to be FRAND, and I'll just say, having defended the Chinese courts, that German courts and UK courts are neutral venues. I mean, I don't understand why they're suddenly not neutral. They're neutral.
I didn't say they were neutral. I said they were applying German law, applying comparable license.
No, you said patent holders weren't going to neutral venues, and I'm saying, well, if they're going UK and Germany, they're neutral venues.
I don't think I said.
Bottom line is, if the UK court says, okay, determines FRAND, however they do it, and we can talk about how they do it and all of that, but they determined this is what a FRAND license looks like. It's not the rule in the UK that is off the table and can't be accepted. It can be accepted, and then there's no injunction. If it's not accepted, well, and the other requirements for injunctions are met, then there's an injunction.
Yeah, or the court will see the evidence and make a decision.
Or the court will see the evidence and make the decision on a case-by-case basis.
One thing I just wanted to say, having participated in these 2 cases that went really the distance, there was a lot of disclosure of existing licenses and the ability of both sides to unpack the licenses and make their case as to which ones were most comparable. And both sides had that information. And even in some cases, the ultimate client, like ZTE, got to see some of it.
But
could I just talk about why I think cases are settling?
Yeah.
You go ahead.
Me? Okay. So look, to me, this again goes to what Eustace's part of Eustace's presentation, which is, well, things seem to be converging a little bit. Why is that? And to me, it's the same reason the cases are settling, because some legal uncertainty has been eliminated. Not completely eliminated, no way, that's never going to happen. But some legal uncertainty has been eliminated over time, right? 10 years ago, there was very strong, no injunctions ever, no matter what, I can do anything I want, I can be as unwilling as I want, you can't get an injunction, full stop. And that was a credible threat. Now that's not a credible threat anymore. And courts are saying in appropriate circumstances, yes, I'll find that a FRAND agreement is worldwide. And so people don't find, there's not the same advantage there used to be in trying to game it. There's more certainty. And at the same time, patent holders know if a UK court is going to set a FRAND rate, you better be reasonable, because if you're not reasonable, then your power to say what your structure of your license should be is going to be taken from you, and the court is going to take it. Those factors, both incentives on both sides, are driving the settlements.
Can I just jump in though? I mean, I think I'm not sure that there isn't an incentive in the UK to aim high if you're the patent holder. I mean, you're going to hopefully skew the court's determination, and even if it's less than what you wanted, I still think there are pretty strong incentives to go in with a big number and have the court say, no, I'm going to split the difference, and you're still ending up at a place, that arguably is above FRAND. So I'm not sure that the incentives are quite the same. Whereas if you're as they've said, if you're the licensee, your risk is getting kicked out of the country. So I guess I would dispute that premise a little bit.
I mean, I think the incentives end up being the same on both sides is really my point, because I think that if you are in if you're in a situation where there are very few comparables or no comparables, then yeah, then people can be unconstrained in what they ask for, and if they think this is going to be a split the baby exercise, they will be as far apart as possible. But I think that's right. That said, if you have a situation with comparables that are going to anchor the analysis in any way, and the meaningful cases very often have comparables, I think parties will be more incentivized to be reasonable. Now, I mean, the other thing is patent holders are going to have to show some compliance with FRAND, even if the UK courts are not requiring them to make a FRAND offer until they adjudicate what's FRAND, which, you can say that's, you can have different opinions about that. But patent holders aren't going to be able to hold on to, no, you have to pay me, $1,000 per phone as a bargaining position. That's just going to look ridiculous.
Yeah, I agree with Fabian there. I think there are two things that will constrain a patent holder from going in and making outrageous requests in FRAND. And obviously one is the comparable licenses. You're going to need to support that, and you're going to look ridiculous, and you're going to completely fail if you go in with a super FRAND offer. And then the second thing is also you run the risk of offending the regulatory authorities, which clearly is not something that you can ignore the possibility of. So I think both of those things will serve to keep patent holder requests in line and reasonable.
Yeah, and I would just say that, the microscope is much deeper in the UK than Germany. But it does.
Yeah, no, yeah. So I agree with that, right? Yeah. Is the UK courts with disclosure and all of that, and have done a more thorough job than the German courts have. German courts are now doing a more thorough job than they did. I agree that some earlier German decisions basically came down to you didn't act as a willing licensee, and so it kind of doesn't matter what the patent holder did. Right. I'm not saying that's the right result either. I think a patent holder has to make a FRAND offer, full stop, and that offer has to be available to prevent the injunction. But that once they've made a FRAND offer, then they've made a FRAND offer.
Just maybe briefly, there was some discussion from Jorge earlier about pending legislation. And maybe, Tim, I don't know if you heard that, but apparently there's a couple of bills where it would facilitate basically determining FRAND rates in the US, if I got that right. Is this something that could happen in the future? Or is there an existing, I think we talked about it, is there an existing way for a patent holder, I guess, or an implementer to get a US court to decide FRAND rates, at least for the US?
Yeah, unfortunately, I missed the discussion of the legislation earlier, but there is an existing way. It hasn't happened a lot, but it has happened. I think the kind of prototypical situation is the licensee is suing the licensor for breach of contract, breach of the FRAND or RAND commitments through the licensing negotiations, and asks the court to determine a FRAND royalty for the portfolio, and the licensor agrees that that it's going to live with that determination, and the licensee does as well. And so that's what we saw in Microsoft Motorola, in TCL Ericsson, later vacated on other grounds, but both sides had agreed to have that happen. And the U.S. judges who have undertaken that effort have, you can disagree with the outcomes and the analysis, but I don't think you can really question the effort that they've put in. The Microsoft decision, the TCL decision, Avadio, all show that these judges, really took an interest and put in a lot of effort to try to get to a FRAND outcome. So I think there's probably a lot to recommend trying to go to U.S. court to resolve a dispute if you can. I think U.S. judges obviously are well acquainted with damages and the apportionment issues that Dave was talking about, whereas in foreign courts, if the injunction is the norm, you're going to have less experience with damages issues, and therefore maybe less aptitude or less experience, at least, with trying to resolve these complex issues. So I don't think there's any silver bullet where you can, certainly there's no silver bullet for a patent holder to go to court in the US and say, judge, make this licensee take a license to my patents on FRAND terms that you determine. I think there's more opportunity for the licensee to go in and say, Your Honor, they've breached their FRAND commitment. We request that you set the rate, and we'd like them to agree to be bound. And maybe they will, maybe they won't.
Thanks. I thought maybe we shift a little to the standard setting organization, and they're kind of setting the table.
Could I just ask Tim a question about
Sure.
that? Because I agree with his description of what courts have done. But my question is, so if the patent holder doesn't agree, right? So you have a potential licensee that says, patent holder, you have breached your FRAND commitment. I'm bringing a breach of contract claim. They bring the claim that you said, right? Shouldn't they still be entitled to the adjudication, even if the patent holder doesn't agree, if they meet all the requirements for specific performance? Why wouldn't that be the case?
I think it could. I mean, obviously, different SSOs operate under different laws, so you need to look at the applicable law, obviously. But yeah, I mean, I think if you seek an adjudication of what the FRAND terms are, and you seek performance by the patent holder under those terms, I think that's probably well within the wheelhouse of a court. I mean, if we had a contract where you were supposed to deliver a certain amount of grain and you weren't doing it, and I went to court and said, Fabian only showed up with 2 truckloads, he's supposed to send me 6.
I hate when that happens.
Yeah, and the court found that I was right. I think a court could certainly make you, show up with what you agreed to do. So I think it is a possibility. Obviously, it depends. Each case is going to be different. The law is going to be different, et cetera. But 100%. Wouldn't rule it out.
Yeah, briefly, I think the problem with that is if you assume all of those things are correct, right? In other words, you meet the requirements for specific performance, you go to the court, you ask for a FRAND rate setting, the court has jurisdiction to issue a FRAND rate, and you go out and proceed to do that. We know what actually happens in reality is that a party goes to a foreign jurisdiction and seeks an injunction. And so the US court's jurisdiction to assess a FRAND rate on behalf of a licensee is frustrated by the availability of these foreign injunctions, which is why the US courts created the anti-suit injunction in SEP cases to say, look, I have jurisdiction to set rates. I can grant specific performance. If you go to a foreign jurisdiction and seek an injunction, you're going to frustrate my jurisdiction, preclude me from doing my job as a US court enforcing US law, and therefore I'm going to enjoin you from doing so. And what do we have now? We now have a international effort to prevent US courts from doing just that, from protecting their jurisdictions. In Germany, if you seek an anti-suit injunction in the United States, you are automatically deemed an unwilling licensee and will be enjoined immediately, right? US courts can't have this specific performance type situation because they will be frustrated as a practical matter by foreign injunction actions.
So why did German courts not, deal with this anti-suit issue? They just don't? I mean, do we have a German lawyer in the room?
Yeah, I'll be there.
Oh, yeah.
Sorry, what I spoke.
No, I'm just saying that if you got a U.S. court to issue an anti-suit injunction to block the German proceeding, is that possible? Would the German court, listen to the U.S. court because it already had the case? In other words, the strategy would be you start the case as the implementer to avoid before the German thing starts.
I actually think who starts it matters, right?
Yeah.
I mean, it was like an unusual circumstance in Samsung Ericsson that Samsung had started it and it still didn't matter. But that was, I think, the peculiarities about notice and stuff in that case that played in. Sorry. I think who goes first matters a lot.
Yeah. So if you started it in the U.S. and you're the implementer, and you get an anti-suit injunction, I guess you can't get that until they file it, right?
Yeah, I don't know.
German courts are quite clear. So no other court has jurisdiction over German national patents. Exactly the same position as the US.
Yeah, there you go.
As well. I could also talk to a couple of other points later on. On German law.
All right, good. Say, don't forget.
but that's sort of my point about the goose and the gander, right? The German courts will assert that parties must pay a certain rate for foreign patents or be subject to being kicked out of the country. But at the same time, anytime a foreign court seeks to enjoin a party from seeking action in the German court so as to protect its own jurisdiction to assess rates for its own national patents, the German courts will not tolerate that. Again, ASIs are a defense mechanism to the use of SEP injunctions. If you don't have SEP injunctions, you don't have ASIs. But the effort to
and you don't have SEPs and you don't have standardization.
Well, I don't think that's the case. But you don't need the ASI if you're not issuing the injunction in the first place. Look, there's lots of penalties that can be assessed if somebody's litigating in bad faith. If you are offering
under German law,
low, you can seek attorney's fees. You can seek damages for willfulness. Right, treble damages. You
not under German law.
Other types of penalties. There's no reason why you need to use injunctions as the sole loan and most extreme penalty for a party that doesn't agree with a patent owner on a FRAND rate.
Can I respond to that pretty quickly? Sorry, I mean that's okay. I think a lot of what you're saying, Dave, it makes more sense in the case of the small the patent holder who has just a few patents to assert. I think it's a different story entirely when we're talking about a company like mine that has thousands of essential patent families. Our ability to obtain sufficient return on investment for the research and development that goes into the standardization and results in all these patents is constrained practically by our ability to only assert low single-digit numbers of patents in individual actions in the United States, in everywhere. And that is a problem that we cannot solve. And we cannot bring, if we have a recalcitrant, unwilling licensee who won't negotiate in good faith for the entire value of the portfolio, then the injunction is very necessary for us to balance the equation so that there is risk on both sides to bring that licensee to the negotiating table.
That's not what I'm saying. I'm not saying you shouldn't be able to get value for your entire portfolio or get a rate setting for your entire portfolio. I'm saying you should be able to get a rate setting for your entire portfolio. You don't need the injunction risk. People disagree in good faith. You might think the right number is 100. I might think the right number is 1. We might both subjectively think we're correct. And then a court tells us who's right and who's wrong. That's how it works.
So are you okay with what happens in the UK then?
No, the UK is telling people not what to pay for UK patents. They're telling people what to pay.
Okay, but then you basically what you're saying is that FRAND has to be at the adjudication phase, country by country at best, right? That's just not how it works. And it's not how it's going to work. German courts don't even set rates, future going rates for German patents. The mechanism for compensation is injunction or damages for past.
I think that's what I said. I mean, parties agree to an international jurisdiction for royalty rates, and yet in the US, and yet companies still go to Germany and seek an injunction for German patents.
So I think maybe we should switch to basically Etsy.
Okay.
Because
a completely non-controversial topic for the end of the afternoon, right?
Well, I mean, I think part of, and thank you all so much for all of this. It's been really great. But should the standard setting organization, take on some more responsibility? And I know because I've talked to a lot of people about this, they're supposed to focus on, getting cooperation to build the future, and that's really important. But can't there be another part of it? Like, I was pulling my hair out badly to get the Etsy data correct until Tim came along. And, at least should that be, Tim's job? Shouldn't the declaring companies be required to update their declarations and indicate, well, first of all, update, what they're declared to, later on after the standard is adopted and it becomes clear. I'm not asking for claim charts, just like an update, so that there's not, all this work that has to be done and it's not really agreed to, right? It's Tim's stuff, not everybody's stuff. So
maybe Etsy should hire Tim.
I don't know. What do you think? Should the standard setting organization take on more responsibility?
I mean, they could, but are they? What are their incentives and what's practically possible? I mean, I say at conferences all the time that all of us could conceive of improvements to the system, right? But yet they don't happen. Why? Because the current system serves some interest at some time, and especially in the context of current disputes, people don't want to change things, right? So you can think of dispute resolution, Etsy adopting a mandatory arbitration model, right? That would solve a lot of problems. You can think of rules about reciprocal FRAND commitments and then no injunctions. That would solve the injunction problem theoretically, right? And as far as the kind of updating the database, well, they could require updates, but then what's the purpose and why are patent holders going through this expense, right? Because the purpose of the declaration is to put people on notice, give some sense, right? Okay, so you do that, and then the standard is done. There's a FRAND commitment that applies. What is further gained by the update? But
are the people real? The people aren't really on notice because they don't really have the correct information.
They're on notice. They're on notice that what they're on notice of is that you think that you might have patents, right? That's what they're on notice of, right? That is it. You can say we should make them put it on notice of what you actually believe. Okay, you could say that, but that has a cost. And what is actually the purpose of that? Is the purpose of that to serve the standardization work, or is it some other purpose, right? Implementers want stricter rules because they want to be able to make patents unenforceable because of footfalls. That's the reality. And you can think of stricter rules, and that have consequences on both sides, and that would be more interesting. I'm very interested to see what happens with essentiality checks. If you have essentiality checks that are third party, that are robust, and that has consequences for both sides, that becomes very interesting.
And what's in play now for these essentiality checks?
I mean, no one really knows. There's lots of ways people are thinking of doing essentiality checks, and some of which are better than others. Everyone believes, I believe, that the European Commission is taking a look at regulation of some kind, either requiring, suggesting, creating a system for essentiality checks. I mean, Japan created a system for like one-off essentiality resolution that no one really uses because there's no real consequences to it. So it'll be interesting to see what the UK does. I mean, it's an interesting idea. Most licensing now, real licensing, is not held up because of lack of transparency in this sense, the lack of knowing what's actually essential. So I think this only even comes into play in some future IoT scenarios that I still think are unlikely, but the European Commission is going to do something, and it'll be interesting to see what they do.
I might be going off the reservation and saying this, so I will again emphasize that these views are my own and not necessarily those of my company.
There you go.
But I do think that I look back to my past experience with the first standardization work that I ever did was in private practice and related to DVDs. And there you had a system where declared patents were adjudged essential by the pool administrator. And it just seems to me really logical that the standards body or the overseer of the standard would be in the best position to judge the essentiality of what people think is and is not essential, but they don't want to get into that business. So consider whether it might make sense for all the parties involved, whether you're both an implementer or a contributor, to somehow we have a tax or a fee system of some sort that pays for independent adjudication to really address the problem up front.
Including validity too, right?
Well, I don't know. Validity, I think, maybe is a little bit tougher because that's a court, a court evaluated decision.
But there's AI for validity. We have to
exactly.
Do we need to go to questions or? Yes.
Oh no, I must have said something wrong.
One thing that a lot of people don't understand, when you go and put in that declaration, or there are patent review boards, companies do all this. When you put it in, the dynamic process of the standard is totally different from the patent.
Yeah.
They come together again years later.
Right.
Do you want to put that burden on the patent holder to go pull that patent, see what it really is, standard person, and then go ahead and say, all right, now I interpret the standard and see if it actually.
Well, I think John's saying the implementers will participate too.
Well, but the third party, as Fabian suggested, and funding that, John, doing funding that, have some type of agreement. That's more appropriate. And standards are to bring the thing in the future and standardize. So,
the additional problem too is that you're incentivized to declare as early as possible. Oftentimes when you're just at an application stage, and over prosecution, your claims change because of what's allowed and what isn't allowed. And so there's that additional level of complication.
So we are in the Q&A.
I think we are. I think we're in the Q&A.
Is
that okay? We're in the Q&A.
Yeah, hi, Jim Harley, InterDigital. I just wanted to comment on you, David, not Djavaherian, but Yurkerwich. You know, the ETSI database was never intended to be a licensing database. Sure. So, right, that's point one. Point two is, and people and declarants can update their declaration should they choose to. So it's optional, it's not mandatory. Right. I just want to make sure that that's clear, that those 2 points are
correct. You're correct.
Illustrated.
Yeah. Sorry.
We went we took the elevator and we went straight into the technicalities in this panel, and I really appreciate it.
Sorry.
So no, it was good.
Okay.
Really, it was meant as a compliment to the experts on the panel. So, but can I pull back for a minute and ask this? So we are discussing all of these issues with, dispute resolution for SEPs, right? And taking a step back, these disputes are happening because you're talking about a technology that is really valuable. That's why people are fighting about it. I guess I wanted to ask a question that, when you said, should the standards organizations do something? Somebody in the morning, I think Jamison Fish, it was you, you were saying that, well, it could be that this whole regime of licensing negotiation strand was designed in a very different environment where there were these big companies that were both innovators and implementers of the technology. Those the Motorola's of the world back in the day that started in inventing 2G and these kind of standards, and were also device makers, and they were doing a whole bunch of cross licensing. And perhaps, in that environment, it worked. I mean, it's just that, we're talking about injunctions, no injunctions. Can we go back and forth? The point is, it's all about incentives. Nobody's going to come to the table and negotiate if they don't have to. So maybe the standards organizations can help, and this is a question for all of you on the panel, by creating the incentives in the first place. Right now, from the old world philosophy, FRAND means a commitment to offer a license on FRAND terms only by the licensors. There is no commitment from the licensees. Tim showed this data on how the universe of these technologies has been expanding. More people are coming to the table. More people are finding value in it. More industries, more verticals, more everything. So should there be a new framework where the SDOs require a pre-commitment both from the licensees and the licensors?
The fact that there's more and more people adopting the standard sounds like a feature, not a bug, for purposes of the patent holder's interests, right? The patent holder has rights under national patent law, and they can enforce those rights. They can also waive those rights. They can say, we don't want to stop people from implementing. We want to allow them to, as long as they pay us a reasonable rate. And then when there are disputes about reasonable rates, luckily we have a system to resolve disputes, whether it's a dispute over the amount of gravel that Fabian's supposed to deliver or amount of money that should be paid in royalties for use of a particular patent portfolio. The fact that there are more and more industries taking on communications, building on those standards and implementing them in their industries is a great thing for patent holders and for standardization. I don't think that SSOs can or should try to impose obligations on third parties beyond the obligation to pay a reasonable rate. And it'd be nice maybe if some SSOs could provide a little bit more clarity around what reasonable means. That would be helpful, and at least a few organizations have done that. But when there's disputes, we shouldn't assume that those disputes are all in bad faith. That seems to be the sort of standard talking point. Oh, if you don't take the rate that I'm offering you, you're unwilling. No, I represent a lot of clients. They just don't agree. And when you don't have agreement, you end up having resolutions. And that's why court resolution, rather than, for example, arbitration, can be beneficial. It sets the rules of the road. And the more clarity you have, the more information you have, the better results you're going to get. That's why I think injunctions skew the debate, because they create resolution based on the cost of market exclusion, not the agreed upon cost of the technology or value of the technology. Value. Well, yeah, if I can walk away and not implement the technology, then we have an agreed upon rate. If the cost of me walking away from a negotiation with you is I'm excluded from the market because I can't implement the standard, then the agreed upon rate no longer reflects the value of the technology to me. It reflects the value of access to the market.
Yeah, I have 2 issues with that, but I will ask other panelists to speak.
Yeah, I was going to help you do that. Thank you.
Let Tim respond.
Tim, would you like to respond?
Yeah, I mean, I think I agree with Dave that there are national laws that allow for protection of patents. It seems hard to imagine a system in which an SSO can impose obligations on third parties who are not there participating at the time that they have signed up for something that they never signed up for. So I'm not sure. I'm just not sure what that would look like, and I have a hard time imagining how that could work legally.
Any comments down there?
I think the only comment I might add is I heard it said at IPVC, and also here today I'm hearing again the idea that somehow arbitration isn't desirable because it's not public enough, that it's not going to lead to standards that can be looked at and used by other people. And to me, that seems like I don't find that to be a very supportable justification for avoiding arbitration. I mean, arbitration should get both the patent holder and the implementer what they need, and should do it in at least a more cost-effective manner, or hopefully more cost-effective manner than litigations all over the world, if we're talking about a global portfolio. And I have a hard time understanding why willing licensees aren't more amenable to that forum.
Fair enough.
All right, so I'll say, Kirti, it would be great if SSOs made things clearer, made things better. But that's not. But in the real world, that's not going to happen. It's just not, because they require everybody to agree, or in the situations where one side or the other can control, it's the implementers who are going to control because they've got the numbers, right? That's what happened in IEEE. So that it's not going to be improved because people won't agree. If that could happen, it would have already happened. So what are we left with? We're left with the rules. We're left with the law as it exists, friend as it exists. And that's been litigated now for a long time, past 10 years or more, in particular. And what you're then left with is, okay, in each country, the patent laws are set up in a certain way that if there's infringement, there are certain remedies. And it's the legal system that each country has calculated that leads to what they believe are the right results. Germany and other jurisdictions have the kind of presumptive injunction system. They don't want courts to be setting things. They say, okay, it's a right to exclude. You're infringing. I'm excluding you. Then you'll come together. And people talk about, it's automatic injunction and all of that. But Germany has protections and bonds and all of that. But let's put that aside. You have the U.S. system that has a very robust damages framework, and injunctions are harder to get. But they're possible if there's irreparable harm. And irreparable harm, a big factor is there an adequate remedy at law? In the US, there's a lot of remedies at law. In Germany, there's not adequate remedies at law. So you end up in the same place, really under the same analysis. And so my point is, I'll try to be brief here. My point is that we are where we are under the law, and where FRAND fits in is, what does FRAND add to the analysis? What is the FRAND obligation? There's certainly a contractual obligation, and that begins and ends with your obligation to offer a license on FRAND terms. That's it. Then there's the competition law or policy glosses on it. That's what people still are fighting on.
Go ahead, Justice.
Yes, I'm not a German lawyer, but I'm still a German. So I wanted to speak to these comments about Germany and the German approach. And I fully understand what troubles you. And there's this suggestion that it's a clear potential that, the German court, by looking at the FRAND offer of the SEP holder, says, okay, I like that rate and I don't like the rate that the other guy is setting, and so implicitly or effectively they are setting the worldwide rate. But I'm getting the impression, first of all, that German courts are not exactly volunteering to look at the rates, and second, that in those cases that did result in an injunction, there rarely were really two offers on the table. And I mean and so that there is it's more often the case that they said, okay, you're claiming that you did not get a FRAND rate, but the reason we are still giving you the injunction is because you didn't make any offer at all. And so if a party says, okay, I was not happy with your rate. Here is my rate. And then I'm troubled with the fact that it's up to the German court to decide which of our rates is going to be friend. Let's agree on some kind of arbitration procedure. Or I'm even offering to have that resolved through whatever other court. I mean, all these would be factors that the court would be looking at to say like whether that's a willing licensee. But like it's in those cases that I've read, like it's more often the case that they said, I only want a German license. And then like it's, okay, that seems to be the solution that you're proposing, but I mean, like that troubles me because it seems so obvious that we end up in a situation where, okay, you get the German court set a German rate and the US court set a US rate, and maybe you do that in 3 or 4 other countries, and then you get it for free in 193 other countries, you know, like, and it just seems like a recipe for paying for a very little part of what you're using, you know, like, whereas the other thing, at least, I mean, I'm not sure whether the German courts are doing it right, but I mean, at least I could see how a court would do it right, where, you know, you look at these things and you say, okay, it looked reasonable. They were trying to get to a solution. And I'm really not getting the impression that the German courts want to set the worldwide rates. I mean, they want parties to work toward a rate. They want parties to put forward something that could potentially work. And I mean, like,
I think they're being drawn into it more, into the details, which is good. But still,
I'm not sure if there
is a problem.
Yeah, I'm not sure there's a question in there. I'm happy to respond to that, but I think we're starting to impinge upon cocktail hours. I want to be careful of that.
Okay, so I'm the least popular person in the room right now. I can just clarify the current state of German law. So courts are looking at what agreements are in place. They're looking at not only royalty rates, also looking at the conduct of the parties. That all comes into frand. And in cases where there's almost 1,000 licenses in place for a particular technology that is now implemented in 10 billion devices worldwide, and the argument is, I don't think your rate is...
What? What are you rooting for?
Cocktails.
Tim, I think, is that you?
No,
I
don't think it's
somewhere else. Sorry.
In the court, in those circumstances, will grant an injunction. It relates to the German patents. Fabian, you're absolutely right. Damages, it's very hard to get. It's limited to the patents in suit or patent in suit, and does not at all impact on what would be paid. So the German courts, Sisval against Hire, said it is absolutely right to hold the sword of Damocles over the head of an unwilling licensee, and basically an injunction to bring the parties back to the negotiation table. So it's not a horrible jurisdiction. I don't think they're trying to exceed. They're certainly not trying to set worldwide royalty rates, but it is accepted, and it's accepted in many jurisdictions. Global portfolio licensing is the norm for ICT-based standard essential patents licensing agreements. Thank you.
Thank you. Should we call it?
Yeah, let's call it.
Okay, we're calling it. Thank you, everyone.
Thank you.
Yeah, thanks everyone for coming.
Glad you could join us.